Let's move on to the big conversation point that we also have lined up for 9 p.m. here tonight. Now, viewers, in the Aryan case, it isn't just Aryan, Arbaz and Munmun who were arrested, but a series of other people. There were 8 people arrested on day 1, and then there were subsequent arrests made basis the conversations that NCB had with them, basis the WhatsApp chats of these initial arrests and people that they were talking to. Several other arrests were made. One of those arrests was the arrest of a person called Archit. Now, in his bail case, in his custody case rather, the NDPS court has given bail on the basis of the fact that the NCB has failed to show specific evidence that this applicant dealt in business of supplying contraband. That except, and this is the court which has said so, except WhatsApp chats, there is no evidence to show indulgence in activity of supplying contraband. And the court says that we can't really say that the accused indulged in supplying the drugs. You cannot say that the accused indulged in supplying drugs merely on the basis of WhatsApp chats, that there is no evidence really to prove that these 5 applicants were part of any conspiracy. Now, let me tell you that the same court, when they were hearing custody hearing for Aryan Khan, also did say that the chats reveal Aryan's involvement, that the WhatsApp chats show that Aryan indulged in illegal activities or that he was in some kind of a drug network. And basis what NCB is saying and these WhatsApp chats that they're saying they have and what they present, we can't really say that he won't indulge in activities if he's granted bail. So actually the WhatsApp chats were seen very differently in Aryan's case by the same court as it is being seen in Archit's case. And here lies in the confusion for many, for which we thought we should bring in the experts to help us try and understand what is the difference. Is it the fact that yes, while WhatsApp chats by themselves are not enough to prove anybody's guilt, it is a crucial part if there are other evidence or indicators, evidence material involved that the investigative agency is presenting. Is that the key difference between Aryan and Archit, both in the same case but with different circumstances? Because both are also facing charges not just of possession or consumption, but also being part of a larger network. So where do WhatsApp chats really stand in the court of law? Can they be used as evidence under NDPS Act, which is specifically for drug dealing? Let's say good evening to Prem Kishan Jain, former Additional Director General of Police in Maharashtra, joining me this evening. N.S. Napannai, advocate with the Supreme Court. Sanket Yanagi, advocate with the Supreme Court. Aashutosh Srivastava, also an advocate with the Supreme Court, joining me this evening. Ms. Napannai, let's start off with you. To the layman, it will be a little confusing to say, oh, but the court said just a few days ago WhatsApp chats are evidence, and now they're saying, differently. How would we explain this?
Pardon me, Tanvi, if it sounds like a little bit like a class on law, but very, very briefly, here is the distinction. Firstly, nothing in law is black and white. We are always living in the gray areas. Second, the one clarification I want to put out very emphatically is, if you are concerned about whether WhatsApp chats amount to electronic evidence or not, the emphatic response is yes, it is an electronic document which you can rely on. The difference that arises is in terms of how do you rely on it and to what extent can you rely on it. There are 3 stages in evidence.
To you. I'm really sorry to you and all the panelists, but Prime Minister Modi has begun to speak at Glasgow. It was supposed to be at 8:30. He's speaking now. We'll have to go across.
एडप्टेशन के तरीके चाहे लोकल हो कि थ्रू पिछड़े देशों को इनके लिए ग्लोबल सपोर्ट मिलना चाहिए। लोकल एडप्टेशन के लिए ग्लोबल सपोर्ट की सोच के साथ ही भारत ने कोएलिशन फॉर डिजास्टर रेजिस्टेंट इंफ्रास्ट्रक्चर CDRI की पहल की थी। मैं सभी देशों को इस इनिशिएटिव के साथ जुड़ने का अनुरोध करता हूं। धन्यवाद।
Thank you very much, Narendra. Thank you, Prime Minister Modi. Let's go now to to Joe Biden, President of the United States of America?
Well, thank you very much.
Okay, we're gonna get you some more details of what Prime Minister Modi there said in that part of the feed that was coming in, being chaired by Boris Johnson. The next speaker there would be US President Joe Biden. We'll get back to that in just a bit. Let me go back to our guest for now. My apologies, Mr. Pinai. Please go ahead.
The three things we have to look at when we are talking about electronic evidence, or evidence for that matter, is it relevant to the case? And what is the admissibility ratio, which is its integrity or, the non-repudiation aspect of it. And the third is proving the contents within the message. So the confusion that seems to be happening in the minds of everybody is that the WhatsApp chat is admissible, is it given in law? The manner and mode of admissibility is through a certificate. That is a separate procedure altogether. Relevance is what will first decide whether the court is going to rely on a chat or, for that matter, any message. And finally, irrespective of whether a document is taken on record or not, you are expected to prove the truth of the contents of the document. Otherwise, tomorrow I will post on social media that Tanvi owes me 1 crore and I will know how to get it on record. That doesn't mean you owe me 1 crore, right? So that's the distinction here.
Yeah, you know what, and thank you for that example, because a lot of people, in the light of several of these instances where WhatsApp chats are getting leaked and quoted, people have begun to talk about, oh, is it okay for me to say XYZ on chats anymore or not, and if it will land me in trouble. But let me bring in some of our other panelists as well. Mr. Yanagi, to you also, if you would want to explain this to our viewers further, how would we differentiate, in the same case, two different accused and two different views?
Insofar as the WhatsApp chat is concerned, firstly, it is only a corroborative evidence and it is not a conclusive evidence.
Yeah.
Based on the WhatsApp communication or the chat history which is available, one has to look into the other circumstances which have been consequent to the WhatsApp communication. WhatsApp communication per se do not prove the transaction. WhatsApp communication only gives certain information about the transaction, assuming for a moment, and that transaction is independently requires to be examined and investigated by an officer concerned who is investigating the matter. So merely on the basis of a WhatsApp communication, one cannot be held to be guilty or innocent as well. But prima facie, there appears that there is a transaction, or there appears that there is something which would be on the basis of a WhatsApp communication. But however, even WhatsApp communication also requires to be proved in accordance with law under the provisions of the Evidence Act, and as much as certain provisions have to be followed insofar as IT Act is concerned. So the question again that arises is, WhatsApp communication nowadays is also not safe. Assuming for a moment a particular person is using a WhatsApp number, a telephone number, or a mobile number, but WhatsApp is being used by someone else. Sometimes it is also possible. So what if whether the different person is using that WhatsApp number for the purpose of communication? So firstly, it requires an investigation as to whether the same person is using the WhatsApp, the same person was using the particular number, and same person has communicated or not, which also requires an investigation and an evidence to that effect. And subsequently, whether the transactions or the communications made thereto have been taken place further and taken further in the matter, that also requires an investigation. It only gives a hint or a clue to an investigation officer as to where he has to head towards for the further investigation into the particular matter in question.
Okay, interesting that you say that. So if we had to take it forward, Mr. Prem Kishan Jain, the argument that it can't just be, essentially, it can't just be the WhatsApp chats. You need a lot more evidence to build your case, and this can be one of the things that add to it. How difficult does it become for the agencies, especially in a drugs case? Now, they are essentially, going back the entire chain. They interrogated 8 of these accused. The NCB claimed that from them they got the lead of this certain guy and several more, and then they arrested them because of these WhatsApp chats. If the WhatsApp chats aren't enough, how difficult does it make the NCB's job to then prove the case in absence of actually finding significant quantity of drugs?
Yeah, thank you, Tanvi, for inviting me today. I would like to depend on a little bit of what both the legal luminaries before me spoke about. WhatsApp chat per se is not a very dependable piece of evidence unless it is corroborated by the actual hard evidence. In this case, now let's take the two cases in which the bail was granted. In the first case, the bail was granted earlier. The second case is an outcome which is today, which you have seen the judgment, in which he says that since 3 accused have already been granted bail and there is no other corroborative evidence on record, that is why the judge has given bail to the remaining 5 accused. Now, earlier, when the bail was not granted in the earlier case, that time the investigation was still on. Now the police custody remand or the NCB remand is already over. Investigation may be going on, but there's nothing concrete on record by the agency in addition to the WhatsApp chats. Now, let me tell you a very basic difference in what the WhatsApp chat and the contents thereof, the veracity thereof is concerned. Now, here there's a conversation going on about the procurement of drugs from an individual A through individual B, and the C is the beneficiary. But where is the actual drugs? Where are the actual drugs which have been obtained by him? And the transactions are 2 years old, 4 years old. So there's nothing that can be proved unless there's a recent transaction, or the transaction at that time are backed by some kind of other evidence, a physical evidence or documentary evidence, which can prove the veracity of these WhatsApp chats. Therefore, the WhatsApp chats by themselves are no evidence at all, and they will not stand the scrutiny of any law for that matter, unless they have some corroboration. So there's no confusion in the two judgments. In the earlier case, when the bail was rejected, it was because the investigation was on, and the court may be hopeful, and the agency was also probably hopeful that they will be able to produce some evidence in furtherance of the WhatsApp chats, which they have not been able to do. And by this time, since 3 of the main accused about whom the around whom the entire case was built up, since they have been granted bail and nothing much is further coming out from the agency, the special court has today granted bail to the rest of the accused. So I think the law is pretty settled. WhatsApp chats by themselves are no evidence unless they are corroborated about the contents thereof, and that corroboration is some kind of an electronic document, or physical evidence, or a physical delivery, etc., etc. So there are so many ifs and buts in that. That is why the confusion in the two judgments. Tanvi.
Let's take it a step further, Aashutosh Srivastava, and say, all right, if they are not considered, WhatsApp chats by themselves are not evidence, then can we simply reduce it to saying they are just, tools for further investigation? Is that how the way forward will be, that it can only help an agency for further investigation?
Yes. See, as per Section 63 of the Indian Evidence Act, it speaks about the secondary evidence, and Section 62 of the Evidence Act speaks about the primary evidence. So now, when computers came into existence in our country, obviously this Information Technology Act was enacted in the year 2000. And Section 65A was inserted, which talks about the contents of a computer. Now, in 2000, obviously, there were hardly mobile phones or WhatsApp or anything. So, I would say that a secondary evidence, this WhatsApp has been considered as a secondary evidence because it is also a kind of a content of a computer. Now, this secondary evidence can be utilized by the investigating agency, whether it is NCB, police, CBI, or CID, or whatever. So they can utilize this secondary evidence to reach to the primary evidence, because it can just be a thread which can lead to the primary evidence of a case. However, if the primary evidence is missing during the investigation, as my friend also said, then in that case, this secondary evidence will not survive so far as the conviction of any accused is concerned. And obviously, in that case, the court will be, at its jurisdiction and discretion to acquit the accused based on only on the secondary evidence. And now, when we, even for this secondary evidence of WhatsApp chats, as per Section 65B of IT Act, there has to be a certificate which has to be filed, and this certificate will include the IP address of the device and all the details about the device from where this information or the chat has originated from. And after doing so, the device also has to be submitted to the court, and it has to be further examined whether this device was really utilized for such kind of communications. And then when the primary evidence is reached out, then only it makes any sense for further for the conviction of any accused. Otherwise it will not survive. But yes, investigating authorities have the liberty to utilize these chats as the secondary evidence so that they can at least initiate the investigation, because no investigating authority can directly come to a conclusion of any investigation. They have to go through whatever the available resource of information is available, whether it's a WhatsApp chat or any sort of computer contents available to them, to enable them to have the further investigation to reach to the conclusion of a matter under investigation. This is
Very well said.
I feel.
Okay.
Very well said.
Okay, so and I'm going to ask some of the questions which you may have touched upon here briefly, but for the understanding of our viewers, because honestly today there is just a lot of chatter about WhatsApp chats mattered there and they didn't matter here. So we're just trying to explain to our viewers of how that really changed. Ms. Napana, you wanted to make a point?
Yeah, I'm sorry. I have been really deeply concerned with the inputs, particularly from the last speaker, and I wanted to clarify, therefore. So first clarification I want to put forth is any evidence in electronic form could be primary or secondary, and therefore I beg to differ from the speaker, and it's absolutely incorrect to say WhatsApp messages by themselves are secondary evidence. To say it carries lesser weight is different from calling it secondary. When you produce the actual mobile on which the chats may have been received, and when that is submitted to court, then that amounts to primary evidence. When you take copies of it and submit it, that's secondary evidence. So we are not really here talking about WhatsApp chats per se, but about the manner in which it is being submitted. So it should not be mixed up. The reason why I was deeply concerned is we have to also keep in mind, Tanvi, that a lot of offenses happen on the chats. In many cases, such as cyberbullying or cyber stalking, the very chat is the manner, the very chat app is the manner in which a criminal reaches out to harass a victim. To tell a public that all this is not evidence is misleading. And therefore, I was concerned to clarify that what we are talking about is the mode and manner of production of evidence and not the evidence per se. So the WhatsApp chat by itself can and in many instances will be primary evidence if the actual document is produced in electronic form. Right? If you're bringing in copies, that is what amounts to secondary evidence. And only in those cases, the Supreme Court has clearly laid down in Arjun Pandit Rao's case that you have to furnish the certificate under 65B 4. Therefore, to say that it's just secondary evidence is a little misleading, and therefore I needed to clarify on that.
Okay, let me ask Aashutosh if he wants to respond.
I would respond. See, I think what my friend said is about the content of a computer. I am talking only about a WhatsApp chat. There have been judgments by the Supreme Court which has clarified this position that a WhatsApp chat cannot be treated as a primary evidence for any case. Yes, as she rightly said, that some of the computer's contents can be considered to be a primary evidence. I'm not talking about the computer content.
I'm sorry, I'm referring to both content from devices as well as computers. There is no difference in law between the two. Anything that's a computing device, be it a computer or a tablet, would stand on the same footing.
Yes, madam, as rightly said by you, the computer contents at some times can really be considered as the primary evidence. I'm talking only about the WhatsApp chat because this case in hand is basically based on the WhatsApp chats what the accused had with some other people who were also accused, and some of them were witnesses. So this I'm talking only about so far as the WhatsApp contents are concerned. So this is what is very clear because the court has clarified. The Supreme Court, even I think Justice Ramana's judgment, if you see in July 2021, which clearly says that only based on the social media and the exchange of messages over WhatsApp or Facebook or any social media that cannot be considered because that can be deleted anytime, that can be amended anytime, and so many changes can take place. So we cannot take it as the primary evidence. This is very, very clear. Yes,
Okay.
but
My apologies for interrupting, Tanvi, but this is absolutely incorrect. What Aashutosh just mentioned about Justice Ramana's was an observation and a statement in court. It's not a judgment. So we should not mislead viewers on these things. The last judgment of the Supreme Court with respect to electronic evidence is that of Arjun Pandit Rao's case, a 3-judge bench headed by Justice Nariman, where it only talks about how and in what manner evidence in electronic form can be introduced, if it is in original form or where it is in secondary form through the certificate. Therefore, we should not mislead the viewers.
no, this is
Okay, so
no, no,
if I may just come in here, sorry, if I may just come in here.
I think my friend
Observations
should,
are different from a
just
judgment.
see that,
My apologies
order
for
which has been
intervening on
passed
that.
in July.
But it's important to
Please see
clarify
the
this.
Please see Supreme Court's judgment which has been passed in July 2021. That will clarify that position which I said.
Okay, let me just take this point across, point of debate now. Mr. Yenagi, do you want to weigh in? Again, because, I must say now I am a little confused myself from where we started, because are we saying that WhatsApp chats can be the primary evidence provided there is more? And do you agree with what Ms. Napina is saying or what Aashutosh is saying?
See, as such, I have already pointed out, WhatsApp chat per se is not a conclusive evidence. It is only a corroborative
Right. I think
evidence.
all 4
Number
panelists
one.
are on board
No, no, one minute,
in
one
agreement
minute,
of
one
that. Yes.
Number one.
Yes.
Number two, the burden of proof is on the prosecution to prove that it is beyond reasonable. The burden of proof is on the prosecution to prove it beyond reasonable doubt that the WhatsApp communication has led to certain transaction, and based on that transaction and the evidence pertaining to that transaction, one can rely upon a WhatsApp communication and say that, look, the transaction has been initiated or there is an evidence pertaining to a transaction in the WhatsApp communication. But WhatsApp communication, as I have been saying, per se is not a conclusive evidence. It requires to be proved in accordance with law, and the burden of proof is on the prosecution to make it admissible. Per se, it is not admissible. That's all is my point.
Okay, Mr. Jain also wanted to come in. Yes, Mr. Jain.
See, what I wanted to say in this case was that now the case which was cited by Madam here was that the cyberbullying, etc., can be, in that case, the WhatsApp chat becomes primary evidence. See, let's not go into the primary and secondary part of it. Even if it is a case of cyberbullying, it's a case of extortion, it is a case of threats, etc. But the other evidence, whether this message was sent from this particular phone or not, whether this chat belongs to this particular number or not, whether it was sent to the destined or the destination number or not, all those things will have to be put in evidence along with the WhatsApp chat. So WhatsApp chat per se will not become the kind of evidence which would go into conviction, which will lead to conviction. What is required is a whole lot of investigation and scientific and documentary evidence to be collected, or electronic evidence to be collected to link the two mobiles, to link the two chats, the chat which was sent originated from a particular number and went to a different number. So, I think we are all on board in saying that the WhatsApp chat per se will not become the evidence. It has to be supported by some other physical, electronic evidence, etc. Tanvi.
Okay, interesting that you make that point. 2 of our panelists want to respond to that. First, N.S. Napinai and then Sanket Yenagi.
Thank you, Tanvi. Very briefly, I just wanted to say that's exactly what I had said even in the beginning, that, a document is only as good as its admissibility with respect to integrity. About the truth of the contents, any document, take a paper document, for instance, even that you would have to prove the contents and the truth of it. Right. So therefore, to say about conclusive or otherwise doesn't change merely because it's a WhatsApp chat or some other chat. It's all about proving the truth of the contents irrespective of the mode or medium. The issue here is about whether viewers are going to think that if there is something that is available to them as evidence in a WhatsApp form, is it something that they are going to lose as evidentiary value or to rely on in a court case. And that's what I'm clarifying to say. They don't lose that piece of evidence. That is something they can definitely rely on in a case. That is something which the Supreme Court also has upheld in various cases, including in terms of proving of contracts, etc., where an agreement in terms of offer, acceptance, refutal, etc., is shared nowadays through emails or WhatsApp chats rather than written documents. Therefore, the way evidence works is the mode and manner of proving the document has been set out through special laws. But the purpose behind us introducing our documents into a case remains the same. Therefore, viewers or, for that matter, victims, people who want to rely on electronic evidence should not get confused into thinking that there is some mode of electronic communications which they cannot rely on. The law is very clear that, of course, you can rely on it. You just have to follow the procedures laid down with respect to how you will rely on it.
On that note, yeah, I'm completely out of time, but thank you so much. Okay, Mr. Yanagi wanted to make a point. Yes, the last word to you tonight.
The beauty of inviting advocates to these legal interpretations.
Yeah.
That you will have multiple angle of discussions on the same point. But anyway, let me dwell into my point now. See that in addition to whatever I have said and in addition to whatever has been discussed so far, I would only say WhatsApp chat, in addition to corroborative evidence, it is of presumptive value. And that presumption is rebuttable always.
Yeah.
And rebuttable presumption, in the sense, it is always rebuttable at the option of the party. Firstly, it has to be proved, the burden is on the prosecution to prove beyond the reasonable doubt. Secondly, it is always rebuttable. It can be rebutted at the option of the defense. So I would say that per se, as I have been saying, or as everyone has been saying and maintaining, per se, it is not an evidence which is admissible in the court of law. It is subject to proof beyond reasonable doubt in accordance with law. That's all is the point.
Well, I must say that while there are different points of view when it comes to legal conversation, it's still always equally interesting to me, at least, to hear all points, and it gives us an insight as to how it also goes on in a courtroom. Thank you so much to all four of you for joining us and really explaining to our viewers why there was a difference in the verdict that was given by the NDPS court. In Aryan's case and in Achit's case, both of them though linked to the same case, but the amount of importance given to WhatsApp chats in Aryan's case was different because there he was found at the location where the raids were carried out. His friend had drugs on him, and the court brought in the argument of conscious possession because the court said that the NCB said Aryan knew his friend was carrying drugs and they were all interconnected, all those accused. The difference with Achit's hearing and case was the fact that he was arrested later basis the WhatsApp chats that were recovered from the original 8 accused, and which is why a lot more importance that was given to just those WhatsApp chats and nothing else that was presented to the court led the court to say this isn't enough. You have to go and find something else for him to continue staying in custody. That essentially is a difference between the two cases. Thank you so much for joining us in this conversation.